Arden, you can come up and have a seat. Thank you.
Thank you, Your Honor.
Record will reflect that we're outside the presence of the jury. In the interest of efficiencies and economy, the court did inquire of counsel about additional witnesses. Mr. Gray, you've indicated that subsequent to Dr. Arden's testimony, you will be resting. Is that correct?
That's correct, Your Honor.
Thank you. Mr. Fleischauer, then that tells me that it is your decision not to testify. Is that correct?
Correct.
You understand, sir, that you have an absolute constitutionally protected right to remain silent. You understand that?
Yes.
Meaning the state cannot call you as a witness, the state cannot compel your testimony in this matter. Do you understand that?
Yes.
However, the flip side of that right is the option to testify, to take the witness stand, to tell your story. Do you understand that?
I do.
That is your decision, yours alone. Do you understand that?
Yes.
Mr. Gray may have given you advice. I'm not going to ask if he did, but I think generally defense attorneys would talk to their clients about the advantages, the disadvantages, the risks, the opportunities. I know that you have family who has been here throughout the trial, and I believe every hearing we've had in this case, and it would not be unusual, my sense is for you to seek their advice and counsel, friends, trusted advisors. But the decision today is yours and yours alone. Do you understand that?
I do.
So you can reject Mr. Gray's counsel, you can reject family's counsel, because you are the one who is in charge of this decision. Do you understand that?
I do.
Has anyone forced, pressured, coerced, threatened you not to testify?
No, Your Honor.
Has anything been promised to you not to testify?
No.
Mr. Fleischauer, again, please don't take offense, but because you're making a very important, constitutionally protected option, I'm going to ask you some qualifying questions. First, how old are you?
44.
What is the last grade in school that you've successfully completed?
12.
Able to read and write the English language?
Yes.
Are you having any difficulty understanding me?
No.
Have you used any alcoholic beverages in the last 24 hours?
No.
Any illegal drugs?
No.
Any prescription medications?
No.
Have you ever been treated for, or do you think you suffer from any mental or emotional problems?
No.
You've discussed all this with your attorneys, your option to testify today?
I have.
And are you satisfied with their representation?
I am.
Mr. Gray, satisfied your client's making a free, voluntary, and knowing choice?
Yes, Your Honor.
Thank you. Satisfied with the colloquy, Mr. Kaiser?
I am.
Thank you. With that said, we'll bring the jury in. Yes, Mr. Gray.
Could we approach?
Yes.
I get it. That's fine. I agree.
And as I understand, Mr. Gray, you will rest when Dr. Arden is done testifying, and Mr. Kaiser, Ms. Ellenwood, you are then prepared to proceed with rebuttal. Is that correct?
Yes.
Thank you. We'll bring the jury in and then hopefully go until lunch and then convene after lunch. Thank you. Please be seated. Mr. Gray, your continued redirect.
Yes, Your Honor. Excuse me. Dr. Arden, you mentioned a couple of times, at least in your cross-examination testimony, that you got information, some information from the criminal complaint in this case.
Yes.
Correct? And during break, have you looked again at that criminal complaint?
Yes, sir.
And in that criminal complaint, which is,
I'm going to object to the contents of the criminal complaint being spread of record.
Well, and again, I haven't heard the question, but Mr. Gray, it's not in evidence, so caution as to its use.
you reviewed a 5-page criminal complaint in this case, is that right?
Yes, sir.
And in that complaint, there were 2 reports, one by Deputy Coleman and one by Deputy Durand, is that right?
Yes, sir.
And is that where you got the facts that you were referring to in the cross-examination and in my direct examination?
Yes, sir.
Now, going to your report itself, the prosecution read a line, you have your report there, go to last page, page 5.
Yes, sir.
He read a line, in consideration of all the evidence discussed above, it is at least as likely that the gunshot wound to Chase was self-inflicted as it was inflicted by another. And in my opinion, more likely. That's what he reported to you, right?
Yes, sir.
And then he quit. And then the next sentence says, therefore, in my opinion, the manner of death should be classified as an accident, correct?
Yes, sir.
And going to page 4 of your report, you first mention in the second paragraph, you repeat some of the facts that were in the complaint, correct?
Yes, sir.
And then you go down here and you state, in addition to the fact that the gun may have been moved, which cannot be reasonably excluded, even despite the typical situation that the gun would fall close to the body if he had shot himself, we also have the results of the recoil testing by Mr. Burton. Is that what you wrote?
Yes, sir.
That testing demonstrated that the same model pistol, when loosely held or supported, could readily travel 10 feet from the point of discharge just from the force of its own recoil, correct?
Yes, sir.
Therefore, the contentions in this incident by the medical examiners and medical examiners that the purported location of the gun at some distance from where Chase was found are not supported by reliable evidence, and even if accurate, do not constitute definitive evidence that he could not or did not shoot himself. Is that what you wrote?
Yes, sir.
That's all I have. Thank you, sir.
Thank you, Mr. Kaiser.
No further.
Thank you. Stand down, Dr. Arden.
Thank you, Your Honor.
Mr. Gray, any additional evidence?
No, Your Honor. Defense rests.
Thank you. Mr. Kaiser, is the state prepared to proceed with rebuttal?
Yep, if I could just have a minute to walk out the hall.
Yes, thank you.
Thank you.
I have exhibits, I just don't want to walk out with these.
Good for you. Thanks very much.
Your Honor, for the record, Dr. Arden is going to remain in the courtroom. And
Thank you. Ladies and gentlemen, counsel have agreed that Dr. Arden can remain in the testimony, or in the courtroom. As I understand, there will be additional testimony which Mr. Gray may wish him to consider. Thank you.
Thank you, Judge.
Mr. Kaiser, state's next witness, please.
State calls Dr. McGee.
Thank you.
Judge, may we approach?
Yes. Please, and raise your right hand for administration of the oath.
Do you swear that the testimony you're about to give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Mr. Kaiser.
Thank you, Your Honor. Good morning. Would you state your name, spell your first and last name for us, and please speak up so everyone can hear you.
Good morning. Michael
You're going to have to pull that really close.
B. McGee, MCGEE, medical examiner, or the past medical examiner for Ramsey County.
I'm going to ask you to speak up a little bit more, Doctor.
Yes, sir.
I appreciate that. Thank you. What do you mean by past medical examiner of Ramsey County?
And I retired January 1st. I still work in the office, but technically speaking, Dr. Mills has assumed the position while I continue to work in the office, finding my replacement.
So what is Dr. Mills' title now?
Medical examiner.
And that was your title, you're telling us?
True.
From when to when?
Basically from 1985 until January 1st of 2020.
Showing you what's been marked as Exhibit 183 for identification. Could you tell us if you recognize what that is, please?
I recognize this, yes.
And what is it?
It is my CV.
So, doctor, how long have you been are you a physician licensed to practice medicine?
Yes.
What's your specialty?
Forensic pathology.
How long or since when have you been a medical doctor?
Since graduation from medical school in 1975.
How long have you been a forensic pathologist?
My entire career.
And just briefly, what is the job of a forensic pathologist?
The job of a forensic pathologist is to either you work for the county or you provide results to a county to help determine cause and manner of death, an investigation of people's death that occur in the jurisdiction, sometimes natural, sometimes not, and if not, trying to help investigators and the family understand what led to the person's death.
Are you board certified?
Yes.
In what?
Anatomic pathology and forensic pathology.
Did you say even though you're retired, you're still on staff at Ramsey County?
True.
So you're still doing autopsies?
True.
Can you approximate in your time how many autopsies you've done?
What I've testified to in the past, it's in excess of 6,000. Do I have any real number? No, I've lost track. It's been almost 40 years, so I've somehow lost track, but it's somewhere in that range.
Showing you Exhibit 150, Dr. McGee. Do you recognize that document?
Yes, I do.
What's that?
This is a copy of the provision of the final autopsy report on Chase Fleichauer.
What was your participation in the autopsy of Chase Fleichauer?
When the autopsy was done of Mr. Fleischauer, I was a medical examiner. While I didn't examine every homicide personally, I insisted on seeing every homicide. So I would usually come in, go over the external examination to see what the results were, and then come back and do the same thing with the internal exam. So I had a clear understanding of what the pathologist was seeing, since I was signing the death certificate, or I would be signing the final report, and in some cases the death certificate. And we did that not only in this case, but on all homicides that went through the office when I was there.
In this case, did the internal exam include internally in Chase's head or skull?
Yes.
So you saw that in person in 3 dimensions, is that right?
Yes.
That autopsy was done on April 15th of 2018, is that correct?
Yes.
And as you indicated, you signed Exhibit 150 concurring in Dr. Mills's opinion, is that correct?
Yes.
What opinion did you concur in regarding cause of death?
Cerebral laceration due to gunshot wound to head.
What opinion did you concur in regarding manner of death?
Homicide.
What, if any, role did the external injuries that you've described play in your decision to concur in Dr. Mills's opinion to a reasonable degree of medical certainty that the manner of death was homicide?
The presence of injuries present other than gunshot wounds.
And what role do those external injuries play in the decision that it was a homicide?
They are part of the overall examination that's done. Normally in suicides, not in all cases, but normally in suicides, you start in firearm deaths. You'll have a gunshot wound wherever it may be located, and generally you have no other injuries present to the body. In this particular case, since there were other injuries, that is of some concern.
Just to get me to my next question, what would be the difference between homicide and an accidental or suicide form of manner of death?
It requires a number of things. In this case, and in all cases of firearm deaths, you have to take the information that's coming from the death scene, wherever that takes place. What the police are telling you or the investigators are telling you what's going on, any explanation of that, plus the autopsy findings. You have to combine them all together. You cannot take any finding separately. You have to combine them as a package. That's what you're supposed to do, is consider the whole gamut of findings.
And in terms of homicide, that would be a killing done by another person, is that correct?
That is the definition of homicide. This is a medical definition, a death at someone else's hand, yes.
And correct me if I'm wrong, is it fair to say that where there were external injuries indicative of a fight, that helps you decide that this was a homicide at the hands of another person?
That is one of the things that raises grave questions regarding the manner of death, yes.
What, if any, role to reasonable degree of medical certainty did the distance of the firearm from Chase Fleischauer play in your decision to concur in Dr. Mills's finding?
It is another component of the external exam or the examination of the outside of the body that causes grave concern. Do all suicides have to be contact wounds? A contact wound is when the firearm, whatever firearm you're using.
Doctor, right now I'm just asking about,
Oh, they interrupted him.
right, because it wasn't, I'm sorry, Judge, objection non-responsive.
Thank you, and Doctor, if you can just answer the question. Mr. Kaiser, question?
And I apologize, Doctor, I asked a bad question. It wasn't what I was looking for.
Ask it again.
Thank you, I appreciate that. What, if any, role did the distance that it was reported to you the firearm was found from Chase Fleischauer's body play to a reasonable degree of medical certainty in your decision to concur in Dr. Mills's manner of death as homicide?
It was a grave concern considering the information we were provided.
And in terms of accidental or suicidal self-inflicted injuries, how, if in any way, does the distance of the firearm being found from Chase's body inform your decision about this being a homicide?
It strengthens it.
In your years of experience and years of practicing your specialty, where would you normally expect the firearm to be in a pistol death of either suicidal or accidental self-inflicted injury?
In close proximity to the body.
Doctor, if you would take a look at Exhibit 150 and look at the bottom of page 5 over to the top of page 6 and just read that couple of sentences to yourself, and then I want to ask you a question about that.
All right, sir.
Thank you. Do you recall whether or not you had an opportunity during the time that you were participating with or engaging in internal examination of Chase Fleischauer's skull to see what Dr. Mills was identifying there in the report as being a linear skull fracture?
Yes.
What did you understand her position to be in regards to how that linear skull fracture originated?
Object to that, Your Honor. His understanding is a vague question.
That's fine. I'll ask you a different question.
Thank you.
Doctor, if I'm wrong, correct me, but do you recall her conclusion being that the linear skull fracture she describes her opinion being to a reasonable degree of medical certainty that that linear skull fracture did not originate with the gunshot?
That is my understanding, yes.
Did you review that actual fracture in Chase Fleischauer's skull?
Yes.
What, as you looked at it, what factors did you rely on in concurring in her opinion that that fracture did not originate with the gunshot?
Fracture lines from the gunshot appear to arrest at the left parietal fracture.
And what's arrest mean?
Stop.
Stop. And what is it about the fracture lines from the gunshot that causes you to believe that there were those there that stopped at the linear fracture, but that the linear fracture did not originate at the gunshot?
Sequence.
Can you describe that for me for more? What do you mean by sequence?
From the fractures, it appears the parietal fracture preceded the fractures from the gunshot wound.
And is that sequence in part informed to you by the fact that the fracture lines you were able to identify from the gunshot wound stopped at the parietal fracture?
That's what I'm saying.
Was there anything else about the location or the angle of the linear fracture at which the fractures from the gunshot stopped that helped you conclude that it did not come from the gunshot?
No, no.
How, if in any way, did that left parietal fracture, linear fracture, which you concurred did not originate from the gunshot, how, if in any way, did that support your concurring in Dr. Mills's opinion that this was a homicide and not a self-inflicted injury?
Object to that, Your Honor.
Basis?
I will withdraw the objection.
Thank you. You can answer, Doctor.
Ask it again.
I'll ask the court reporter to read it back.
Question: how, if in any way, did that left parietal fracture, linear fracture, which you concurred did not originate from the gunshot, how, if in any way, did that support your concurring in Dr. Mills' opinion that this was a homicide and not a self-inflicted injury?
The answer?
You can answer.
Suggests that there was prior trauma or the fracture was there prior to the gunshot wound.
Given what you saw of that fracture, did it appear to you to a reasonable degree of medical certainty that that fracture would have occurred at or around the time of the other physical injuries that Chase Fleischauer suffered before he was shot.
Yes,
And you hold that opinion to a reasonable degree of medical certainty?
yes.
What was your opinion to a reasonable degree of medical certainty, having the opportunity to actually see the wound in Chase's head, regarding the degree to which, if at all, after he was shot, other than falling, that Chase Fleischauer would have moved at all?
I don't believe he would have moved appreciably other than the falling sequence. Probably not very much.
You saw the, tell me if I'm wrong, you saw the blood on the bottom of his socks?
Object to this, Your Honor, is bleeding, repetitious.
It is leading sustained.
How, if in any way, did what you saw on the bottom of Chase's socks help inform your decision to concur in Dr. Mills's opinion that this was a homicide?
Suggested the subject stepped in blood at the scene.
Tell me if I'm wrong, that would have been before he was shot then.
That is one possibility, yes.
And can you tell me to a reasonable degree of medical certainty whether or not the injuries that you saw that preceded or came before he was shot were injuries that medically could have produced, for instance, a bloody nose or something like that?
Yes.
And the external injuries that we're talking about, as well as the skull fracture, and if I'm wrong, please correct me, but would it be fair to say that those injuries would have been consistent with Chase Fleischauer having been in a fight?
That was one of the conclusions that we drew, yes.
Nothing else.
Thank you. Counsel, wants your approach a second?
Dr. McGee, the cause of death in this case was a gunshot wound to the head, correct?
True.
No question about that, right?
True.
And none of the injuries that you've been asked about had anything to do with the cause of death, correct?
True.
And you also know, through your investigation in this case, and through your own policy there at the medical examiner's office, that you test for gunshot residue, at least back then you did, correct?
True.
And what you did, and you or Dr. Mills or perhaps somebody else, Chase Fleichauer had his hands bagged, is that right?
True.
And you took the bags off the hands and you took your kit, you did, Mills did, somebody did, and rubbed on the palm of Chase Fleischauer's hands, correct?
True.
And why did you do that?
Collection for GSR samples, or gunshot residue samples.
And why do you try to get GSR gunshot residue samples?
Samples are collected on all firearm desks to see if their hands are in approximation to the weapon when it was discharged.
Okay. And in this case, you got the results back, correct?
True.
And there were, I think it was 21 particles of gunshot residue on the left hand and 17 gunshot particles on the right hand.
I believe that's correct, yes.
And that would tell you that he was in close proximity of that firearm.
True.
Or he may have fired it himself.
That is one possibility, yes.
And directing your attention to page 6 of your autopsy, I'm sorry, I might be wrong there. Page 7 of your autopsy, top paragraph,
Yes, sir.
3 lines down, there are two 1 3/4 inch red contusions, abrasions on the back of the right index finger, and that'd be the trigger finger, correct?
True.
And 1/8 inch cut on the right ring finger, correct?
Correct.
And 1/8 inch abrasion on the back of the right hand. Well, forget the back of the right hand. The injuries to the finger, that in a reasonable degree of medical certainty could be consistent with accidentally firing that gun and the gun flying out of your hand, correct?
That is one possibility, yes, sir.
And you also learned that there was no gunshot residue on Kayle Fleischauer from his testing, correct?
That is our understanding, yes, sir.
And you also learned that the DNA in the case, there was DNA in the pistol, correct?
Yes, sir.
But there was, from the experts or from the people out in Madison, they did not test for blood on the gun.
All right.
But why they didn't, apparently, was why they didn't see any blood on the gun, correct?
Yes.
There was, however, DNA of Chase Fleichauer found on the barrel of the gun, correct?
Correct.
And with respect to the GSR, if Kayle Fleischauer, if there's no evidence he washed his hands between the time he was handcuffed and the time that the nurse took the swabs, that would be an indication to you that he wasn't around when the gunshot was fired, correct?
True.
Now, with respect to the distance of the gun, you testified prior, and you testified today that in an ordinary situation for suicide, somebody intentionally shoots himself, the gun lands 1.5 feet or underneath the body, correct?
In most cases, yes.
And accidental shootings, is it your testimony that that's also true in accidental shootings?
If no one is, if the gun isn't inadvertently moved, yes.
Okay, well, have you reviewed or seen the testing of Corey Burton and the recoil of this pistol?
If we're referring to the same thing, I've seen part of it, yes.
Well, have you seen the testing where the gun flew, when it was held, the gun flew up to 10, I think 12 feet?
Yes.
And if the gun, and have you seen the video of the recoil of this gun held by, I believe it was Detective O'Keefe? Did you see that?
I did not see that. I only saw the one using the inanimate object.
Okay. And that recoil, you saw that, you agree that if the gun was fired as it was, that the gun would fly back up to 10 feet.
Objection calls for this witness to make a conclusion regarding.
Sustained as to the form of the question.
Well, you did see those, correct?
Yes.
And that does not change your opinion at all?
No.
So even if somebody accidentally shoots that gun, looking at it, and it goes off, you're saying that the gun would still land right down below?
In most cases in our office, in those situations, yes.
No, but not in all cases.
I cannot sit here and tell you every case, it's always going to be the same. No, I'm not going to say that. I can
When
only
was the
tell you
last,
about
excuse me, when was the last time you had a case where there was an accidental gunshot?
last week.
Okay, and was the person who did that, was it self-inflicted?
You're talking about accident or suicide?
Talk about accident.
Well, accident would be sometime in 2019. It wasn't last week, but it was in 2019. I'm sure we must have had an accidental shooting, sure.
Well, you don't remember it though?
I'm sorry, sir, I don't.
No, okay. But was that a self-inflicted?
It was, yes.
So in that case, the person holding the firearm shot himself.
Yes, that's our understanding, yes.
Self-inflicted? You agreed, do you know about the unspent shell casing in the living room found in this case?
I don't believe I can answer that, no.
You're saying that the injuries on Chase Fleichauer enter into the whole picture as to whether or not this was homicide or suicide, correct?
Yes,
What's all of the other factors I just mentioned? The gunshot, at least you saw the video of the gun flying, the DNA, the GSR, none of that causes you to rethink your homicide?
no, sir.
And you mentioned the injuries that played a part of this. Now, you're not talking about the injuries having a motive for the person that's deceased holding the gun. You're talking about the injuries of the deceased being shot by somebody else because he has these injuries. Is that what you're saying?
No, I don't think that's what I'm saying. What I'm saying is the presence of the injuries suggests that that's something that we normally do not see on suicides.
We're not saying this is a suicide, sir. What I'm asking you is, oh, okay, I'll withdraw that. So what you're referring to here is if a suicide, you don't normally see those injuries.
That's right.
Okay. And it would be consistent, would it not? Withdraw that. Give me a second. Did you see any other videos or any other demonstrations of this pistol recoil flying somewhere?
No.
And did you bring your notes with you with respect to viewing the inside of the skull of Chase Fleichauer?
There are no notes, sir.
No notes?
No notes, sir.
No notes of Mills either? Is that it? Dr. Mills?
I don't know if Dr. Mills took notes or not. You'll have to ask her.
Okay, and you didn't take any notes though?
No, sir.
And you've done many autopsies since then, correct?
Yes, sir.
And many before, right?
Yes, sir.
One second. Thank you, Doctor. I'm done.
Thank you. Mr. Kaiser, any redirect?
Couple things, Judge, thanks so much. Dr. McGee, how in any way, into a reasonable degree of medical certainty, do the external injuries Chase Fleichauer suffered distinguish this case from other accidental shootings that you've examined?
If they do, Your Honor.
If they do, that's fine.
Thank you.
Generally speaking, accidental self-inflicted gunshot wounds have a minimum of additional injuries.
Have you seen other cases where persons have been in a fight and been shot?
Yes.
Can you think of any of those that weren't, based on your training and experience and the autopsy itself, as well as the investigation, ruled a homicide?
I would object to this, Your Honor. It just,
Sustained.
Question was asked about, apparently, the hands being bagged in order to be able to recover gunshot residue. Do you recall being asked that question?
Yes.
What is the bagging of the hands designed to prevent?
Contamination.
By what?
Well, basically, anything landing on the hands that's not there from the time of the subject's death. That's the purpose of it.
It was posed to you whether or not the hands were, and I quote, rubbed in order to get to the GSR. Are the hands rubbed to get to the GSR, or are they stamped with a stamping tool?
The latter.
Stamped.
Yes.
All right. What, if any, effect would rubbing a place where there may have been gunshot residue have on the ability to recover gunshot residue?
I'm not really sure. All I know is we've been taught to use the stamping procedure, so have I ever tested rubbing versus stamping? Actually, no.
That's fine. Would it be fair to say, and if I'm wrong, please correct me, would it be fair to say that if one were to bag the hands, a reason to bag the hands is to keep them from rubbing up against anything and disturbing gunshot residue if there is any?
Yeah, that's a purpose, yes. Mm-hmm.
You said what the gunshot residue test results advised you was that Chase Fleischauer was in close proximity to a fired firearm. Is that correct?
True.
Fair to say that his gunshot wound also advised us that he was in close proximity to a fired firearm?
True.
So the fact that he had gunshot residue on his hands to a reasonable degree of medical certainty contributed nothing to your decision to concur in the opinion that this was a homicide.
object
Is
to
that
that
correct?
as leading, Your Honor.
Well, ask it in the form of an opinion, Mr. Kaiser, as opposed to a statement.
How, if in any way, did, actually I have to do a sequence here. I apologize, I'm sorry.
I see 169.
Doc, do you still have Exhibit 150 up there with you?
Yes.
And that was the autopsy report, is that correct?
True.
Could you take a look through there and see if you can figure out what date that was issued on?
I signed it on May 10th, 2018.
Showing you what's been admitted in Exhibit 169. Do you recognize that document?
I do, yes.
That's the GSR test results on Chase Fleichauer that came to your office, is that correct?
True.
What date did that come into you, or at least what date is the report dated?
At the top, July 31st, 2018.
So that's a couple months after the final protocol calling this case a homicide was issued, is that right?
That's true.
Now, were you and Dr. Mills and your employee at the time so entrenched in your opinion that it's a homicide that you just refused to pay any attention to the GSR?
Object to that, Your Honor. It's argumentative, leading, repetitious.
Re-ask it, Mr. Kaiser.
Do you recall whether or not sometime shortly after Exhibit 169 is dated that you had an opportunity to review it with Dr. Mills?
The GSR results?
Yes.
Yes.
Now, you had already, can you tell me if I'm wrong? Please correct me. Can you tell me whether or not you reviewed the GSR report regarding the gunshot residue on Chase Fleischauer's hands in relation to your conclusions from May 10th of 2018 that this was a homicide?
Yes.
To a reasonable degree of medical certainty, what, if any, conclusion did you reach regarding whether or not that GSR report was going to change your opinion that this was a homicide?
Object to that as repetitious.
Overruled, you can answer.
Ask it again, I'm sorry.
I'll ask the court reporter to read it back.
Question, to a reasonable degree of medical certainty, what, if any, conclusion did you reach regarding whether or not that GSR report was going to change your opinion that that was homicide?
I guess the answer would be, it was our opinion it was a homicide before the GSR, and the GSR sample strengthened it, but that's our opinion.
How, if in any way, did the GSR report strengthen your opinion that this was a homicide?
Presence of the particles on both hands,
Showed what?
close proximity to the weapon at discharge.
Given that close proximity, hypothetically, to a reasonable degree of medical certainty, could that close proximity explain Chase Fleischauer's DNA on the barrel of the pistol used about a half an inch inside the barrel?
Object to that, Your Honor, as evidence not, it's not in evidence, a half an inch in the barrel, that was never testified.
Sustained as to the form of the question.
Can we approach?
Yes.
In your experience, based on your training and experience as to the effects of a gunshot wound on the human skull, would you have an opinion to a reasonable degree of medical certainty whether, given the proximity of Chase Fleischauer to where the bullet left the pistol, that it may have caused DNA to be present on the barrel of the pistol close to where the bullet comes out of the gun?
Object out of his realm of knowledge, Your Honor, and foundation, he's not an expert.
Well, based on your training experience, doctor, and this is all, again, all these questions asked by the state have to be to a reasonable degree of certainty in your field. So with that foundation, if you have an opinion, you can state it.
My opinion is it possible? Sure, it's possible, assuming the gun is close enough. That's about as much as I can say.
Yeah. So if the testimony in the case has been that the gun was about 5 or 6 inches away.
Is that possible? Yeah, yes, I imagine it's possible, yes.
I don't want your imagination, though, to a reasonable degree of medical certainty.
Now, I don't say that I cannot sit.
Well, please, there has to be a question followed by an answer. And doctor, again, you can't testify to what's possible. You can testify to what's medically probable within your field. So with that, again, that foundation, Mr. Kaiser, the question.
Okay, with that, no, I can't.
Now, you characterized the object in the video recording that you watched as an inanimate object. Do you remember testifying about the inanimate object in the recording?
Yes.
What was it about how that production was done that causes you to a reasonable degree of medical certainty to find that it does not change your opinion regarding whether or not this was a self-inflicted injury or a homicide?
Excuse me, Your Honor, I object to that because he stated he watched portions of it. He didn't watch the whole thing.
Well, as to those portions you watched, do you have an opinion?
Of the portions that you watched?
Yes. I have an opinion.
And what is your opinion regarding how, if in any way it does or doesn't affect your opinion regarding the manner of death?
It was done with a non-human subject. What I saw was a non-human subject, and I'm not sure that you'd have the same response.
What is it about a human subject holding the pistol that affects the response of the firearm?
I think a hand is different than the object I saw holding the weapon in the video.
Thank you, Doctor. No further questions, Your Honor.
Thank you, Mr. Gray.
Thank you. I neglected to mention, when you're taking everything into consideration here, you also were aware in determining that it's a homicide and not a self-inflicted accidental gunshot wound, that Chase Fleischauer was sitting on a stool, correct? You knew that?
Objection. There's no foundation for it in the record.
I'll sustain as to the form of the question.
Well, Your Honor,
Well, again, Mr. Gray.
hypothetically, in this case, Investigator Stalkey came to the opinion, because his feet, Chase's feet, were inside of the stool, that he was sitting on the stool at the time that the gunshot went off. All right? Assume that.
All right, sir?
Okay. Now, assume also that while he's sitting on that stool, he's got a .278 blood alcohol count. Okay?
All right.
Were you
Objection outside
aware-
the scope.
Pardon me? Well,
Technical.
I'll move the.
Let's ask the question, Mr. Gray.
Okay. That Chase Fleischauer at that time had a .278 blood alcohol count.
All right.
And you knew he was 19 years old, correct?
True.
And did you know that the unspent cartridge in the living room was from that gun? Did you know that?
No.
And while sitting on that stool, he had a .278. What is a .278? What does that mean?
Objection asked and answered outside the scope, not by this witness, but it's cumulative at this point.
Overruled. You can answer, Doctor.
It's an elevated blood alcohol.
It's over 3 times the amount that you cannot drive with, correct?
In Minnesota, that's correct.
In addition to that, it's in a 19-year-old youth, correct?
Also true.
Which also affects your observation of the situation, correct?
Yes, sir.
And then we go to the GSR, the gunshot residue, and you say because there's gunshot residue on Chase Fleischauer's hands, that strengthens your opinion that he was shot by somebody else?
In this case, yes.
And he could also hypothetically, or assume, that gunshot residue on his hands were from holding the pistol and it accidentally going off, correct?
That is a possibility, yes, sir.
Well, is it a possibility, or is it as much a possibility as somebody else shooting him? Are they both equal?
No, I would favor in this particular case, it would be from someone shooting him.
And that's from the injuries he had prior to this?
Coupled with the injuries.
And you're basing that on the injuries he had prior to this? Is that what you're saying?
Coupled with them, yes.
What's coupled with them? What else is?
Taking them all together, sir. All
What
the
else is
injuries,
there?
the injuries, the GSR, the entrance gunshot wound, all taken together.
3 to 6 inches is a gunshot space.
Right,
31-inch hands could easily shoot himself, correct?
that's true.
Okay. And it is true that, let's see the date on it. Did you have, withdraw that question, Your Honor. And that, anything about the temporal bone, that wasn't mentioned in this autopsy.
Now we're outside the scope, Judge.
Mr. Gray, we are. Thank you. Next question.
May I approach, Your Honor?
Yes.
The autopsy report, there is nothing about the temporal bone being inflicted prior to the gunshot wound, correct?
No,
Correct?
that's correct.
Okay, that's all I have. Thank you.
Nothing else.
Thank you, Dr. McGee. You can stand down.
Hey, Judge.
Ask you to be excused from his subpoena.
So noted.
Thank you.
Do we have another witness, Mr. Kaiser?
Not right now, Judge.
Thank you. Ladies and gentlemen, we're going to break for lunch. It's a little bit earlier than what we ordered your meal for, but we did call about a half hour ago and ask if they could accelerate, so well, hopefully it'll arrive hot. With that said, don't form your opinions, may any discussion, start your deliberations. Let's plan on reconvening 45 minutes after your meals arrive. Thank you. We're adjourned.
Your Honor?
Take the jury out, please.
All rise.
We're off the record.
Yes, could I have the rebuttal witnesses, so if I don't have the files, I can drive up to my home in Woodbury and get them?
can figure that out. Thank you.
Thank you, Judge.
We're adjourned for lunch.